If you are not legally protected in your business, you are leaving money on the table. Hey, I get it. The legal side of business can feel intimidating, but the good news is it doesn't have to be. If you want to build your business on a strong foundation, and if you want to know that your rights are protected when the unexpected happens with a client or a customer, then it's time to get legally protected. This means no more using free contracts that you downloaded off of the internet. This means partnering with a law firm that actually believes in your vision and can help you achieve it. This means legally protecting your brand so that no one can steal your good ideas. There are a lot of ways to grow and scale, but if you want to grow a strong business, it's time to get legally protected. If you're listening and resonating with this, then my signature service, the Legal Upgrade, just might be perfect for you. The Legal Upgrade is a straightforward, structured process to give your business the legal protection that it needs to thrive. Click the link in the show notes and schedule a call with me today. Hello and welcome to the Legal Upgrade Podcast. I'm your host, licensed attorney Christian Hammond. This podcast breaks down the legal side of business to reveal key legal strategies that can help you take your business to the next level. Please note that none of the following is legal, tax, investment, financial, or medical advice. Without further ado, let's get into the show. Let's talk about trademark licensing because I think this is something that companies struggle to do well and something that companies struggle to make work for them rather than having it turn into something that becomes a bigger problem. And so trademark licensing at its core is about letting somebody else use your trademark in exchange for some kind of money. Usually reoccurring money. Maybe they're paying you monthly, maybe they're paying you yearly. A cousin of licensing is franchising, but they are two different things. So there is a difference between trademark licensing and having a franchise and the difference is that when it's a trademark license, you own the trademark, you're letting other people use it under a license agreement, and they're paying you reoccurring revenue. In a franchise situation, that is usually, think about McDonald's. McDonald's is a franchise. And so other people buy into the franchise. It's usually a pretty significant amount of money. And they get to open their own location and they get to run their own business under your trademark. But typically there's also pretty stringent, or there has to be really stringent controls around this is what the burgers should look like, and here are the recipes, and here's how it all works. So licensing and franchising have a lot in common, but they are different things. But I want to focus on licensing because I think this is something that companies, like I said, they struggle to get it right. And in particular, there is this phenomenon I have noticed where when you allow someone to use something, it's not too long until they can start to get confused and kind of think that it's theirs. And what I mean by that is that I've seen companies license their trademark to others, and that company, that business entity they've licensed it to, can actually end up being one of their biggest copycats, one of their biggest infringers. But that happens when things were not clear at the beginning. And so the first thing that I see companies getting wrong is not making it very clear, hey, I'm licensing my trademark to you, but I'm not giving it to you. You don't own it now. And one of the ways to make that clear is to put really strict controls around how can they use that trademark? And is it really clear when our relationship is over? And is there a process where they need to give you back your files? They need to give you back your materials. They need to give you back any templates that you gave them to use. And so the first thing I find really important is making sure that licensee understands that they're just renting. They are not owning, they are just renting. And I've seen that definitely become a problem. I've even seen companies license their trademark to someone, and then that person turns around and tries to trademark their trademark. That is a whole issue unto itself, but that goes to show the trouble with licensing is that if you give a mouse a cookie, the mouse might think that they own that cookie. So it's really important to be clear around, okay, I own this and I'm just giving this to you to rent. And by the way, you have to pay me the rental fee and you have to pay it regularly. And maybe that's another issue when it comes to enforcing that licensing agreement. And so when you're thinking about, okay, I have a trademark and people want to use my brand, people want to co-brand with me, people think that we can have a really beneficial partnership, all of that is great. But maybe the first thing to think about is, am I ready to enforce that kind of licensing agreement? Am I in a position to make sure that they're representing me well? Because when you give someone else the right to use your trademark, your brand, and your name, that's a lot of power, because you used to fully control how people perceived your brand, but now you're handing over some of that permission to somebody else. And the question is, are they going to represent you well? Are they going to maintain the brand standard that you've been maintaining? When people go onto their page and their website and see your name, is that going to be a good association, or is that going to be a mixed association? And so all of these are things to think about, and all of these are factors for whether a trademark licensing agreement really makes sense and this is something beneficial, or whether you might need to consider, okay, do I first have the infrastructure I need to really make a trademark licensing agreement work for me? Another issue I've seen is, and this tends to be with companies that have multiple levels. So maybe you have a parent company and then you have subsidiaries. I've seen there be trouble when the owners are not clear on who really owns what. They're not super clear on what the parent owns, and they're not super clear on what the subsidiary owns. And that can be a problem from a trademark perspective. And what I've seen some companies do is that they'll have the subsidiary get the trademark, but it actually is the parent company that is the face of the brand. And so what happens is the parent company is actually using the trademark, even though the subsidiary company owns the trademark. And that is an issue unless there's the right licensing agreement between those two entities. So if you own a company that has multiple levels and you're maybe running different brands out of the parent versus the subsidiary, it's really important to be clear on which company needs to use the trademark, and that informs the decision which company should then apply for that trademark, because you can't just treat a parent and a subsidiary company as if they are interchangeable. All right, so that's all I have for you guys today on trademark licensing. Thanks for watching.
Hey, thanks for listening to the show. The Legal Upgrade Podcast is a Bevel Law production. For more information about the Legal Upgrade, you can follow on Instagram at Bevel Law, or find even more information on the website bevellaw.com. If you enjoyed the episode, please remember to subscribe, leave a review, and share it with a friend. See you next time on the Legal Upgrade Podcast.